Okay, we're online and
14 people.
well, 11 of them are us. Attendees, we have 3, including our administrative analyst. So I think we're probably ready to go. I don't see more people coming in.
Okay, good. All right, then we'll go ahead and convene our or begin our December 17th meeting, the last meeting of the year. And we'll go ahead and start with the minutes. The first
You got
item.
the minutes.
Second.
Are you guys in a hurry?
That's fine. If I had needed to make changes or propose changes, I would have to insert that now, but I'm not recommending any changes this time.
Okay, good. Then with the 2 motions, we'll go ahead and adopt the minutes, I guess, or move forward to the second item. Steve, we haven't seen you. I'm glad to see you here.
It's nice to see everyone.
I know,
Absolutely.
I heard your voice and I thought, I don't see you in the panel.
Out of the
Like,
past, right?
weird, but good to see you. Number 2, and I only think of you because of the second matter with regards to our report, annual report that's coming up.
Yes.
All right, we'll go ahead and move to item number 2. Brian.
The Executive Director's Report. I have a couple of things to discuss. One is good news, which is I have the opportunity to express appreciation to a couple of our staff members. One of them is Deborah, who's in the audience, and I'm enabling her to talk, but I don't think she was expecting this. So up to her whether she wants video on, who knows where she is.
Deborah, I want to see you. I haven't met you in person. She's probably like, great.
I'm working on it.
We've had the practice for the last several years of specifically recognizing employees when they hit the 15-year mark in their tenure with the commission. And both Steve and Deborah were hired to work in their jobs here 15 years ago, both at slightly different times, and I don't honestly remember the dates.
Very close.
Are we close to the anniversary date?
We're a little bit past, but I think Deborah and I were hired almost the same day. I mean,
Wow.
Steve was a month before me. Am I on?
Yeah, we can hear you.
I can't bring my video up. Do you have my video?
No.
It's a good trick that I learned. What's that? Just say, oh, it doesn't work.
So, and we also have the tradition, and the state permits us to spend a modest amount of money on recognition awards. So we have a couple of objects that I think are going to show up interestingly on the Zoom.
Wow.
You can kind of see it.
It's an acrylic paperweight. And there's one for both Steve and Deborah. I'll hold Deborah's up for the permanent video record that's going to last into the next century.
Nice.
So they read California Law Revision Commission thanks Stephen Cohen or Deborah Larrabee for 15 years of excellent and dedicated service. And then it has the state seal. And these are kind of nice. They do laser engraving on the back face, which just makes it a little bit more opaque. And then you look at the language through the front of it, and it's got some good heft to it. So what I'll do is one of these days when I go into the office, I will leave these in your desk drawers or something for you. And then in another 15 years, you'll be able to go in and pick them up, because I imagine that the pandemic will be over by then.
Oh my God.
Oh, I thought you were going to say I could trade it in for a 30-year plaque.
There you go. Me too, Steve.
It's super, super sweet that you guys even thought to recognize us. I was trying to get my video up because I actually am in a fine location, but I can't seem to find the option. That's why I thought maybe it was in your control. But
the lower left corner, Deborah, do you see where it says mute? If you move your cursor over to the lower left corner of the screen, do you see there's a mute and a video button?
I don't have the video, just mute. That's why I only have the mute option. I don't know if it's because
hold on a second. I'm going to promote you to panelist and see if that makes a difference. maybe this was my problem all along. And I should say that it was a bit of an accomplishment for me to order these things, because normally Deborah would do that.
There
for
she
me.
is.
Hey, Deborah.
Hi.
Well, now that you're here, do you mind, Brian, let's take a moment just to clap for you, because for both of you guys, that is an accomplishment. 15 years is a lot.
It's been a pleasure. It really has. And Brian's been a great boss to work for, and the staff have been unbelievable. So it's been a great 15 years.
We're
And
small
I-
enough that we're either a happy family or a dysfunctional family. And I think we've been a happy family.
Absolutely.
Also,
easy to go
thank
the
you.
other way.
My thanks also. I really appreciate this. Didn't have any idea that was coming. It's wonderful. Thank you.
And to add a little context for Steve's status, because I know it's been a bit confused, was way back in May was when we were required to set a person aside for contact tracing. And I did my best to get out of it, and they wouldn't allow me to. So Steve was selected for that. And because we had been expecting that he might at any moment be whisked away and completely unavailable for 6 months, I took him off of working on main projects where you would see him showing up at meetings. Instead, he's been doing a lot of assistance behind the scenes. And now, I mean, even however many months it's been since May, we're told that he might be assigned very soon, and again for another 6 months. So as nice as it is to have him back today, you may not see him again until August or July.
Oh, no.
We'll see.
We'll
unless
see.
unless they mess it up again, in which case he'll be back at the next meeting.
It may depend on whatever I'm doing, because there could be breaks that I might be able to be here. Well, I guess we'll just have to see. But it's
Yeah.
nice to see everyone now anyway, and I hope to
I've
see
missed-
everyone again soon.
Good. And then you know what, too? Thank you for your service, because seriously, that's hopefully you guys will, help to put a dent in the pandemic. So, so this is good. Look at it as public service to the hilt.
Right.
So
Right.
the other item I
Thank
had for the executive director's report is that I would like to suggest that we cancel the January meeting. Today's meeting I'm expecting it to be brief, and January's meeting would be briefer because there are some sort of external forces impinging on us. One is that this is the time of year when we're gearing up for the legislative program for the next legislative year, finding authors, working with them on introduction, all that business. And we're actually having to do that for 2 years worth of bills, since last year's bills got withdrawn for the most part. So there's a lot of that kind of work. And then the other thing, and this is beyond the commission, but Barbara and I are both working also for the Committee on Revision of the Penal Code. And the way they've structured their work is that they plan to do one big annual report full of recommendations that reflects the prior year's deliberative work. And this is the first time they will be doing that. So they have no template for it. And it really is a lot of material to process and put into a good form. And so Barbara and I are both going to be working on that. And then the other thing is, there's holidays, the Christmas holidays, New Year's, both which eat into the time available before January. And Kristen's going to be continuing to work on finalizing the recommendation on toxics, which, while that's a lot of staff work, really only requires a few minutes of commission time if she's done it correctly. Because, as long as you don't have concerns about it, then you can just vote to approve the final product. So I really think if we were to meet in January, there would be very little to do, and that it might be better to release us from that time frame and just reconvene on our February date.
Sitting in front of a prison background, according to Brian, so I think you guys should be released. Do you want to vote, though, for the record?
I saw a couple of thumbs. Why don't we see, does anyone oppose that or want to abstain from that decision? And then everyone's showing the general assent, so I'll take it as unanimous.
There you go.
Okay, that's all for the executive director's report.
Thank you.
Yep.
And then you guys, this has been a hard year. I just wanted to share, take a moment just to say that, because you know, we all have been, it's funny to us to live on Zoom, but this is trying and this is difficult and it requires all of our attention. It's a different way of working. Not to mention, we started, you guys were new. We had new commissioners that came all the way to Sacramento, and now
One meeting, you
who
got it.
knew that was probably going to be it for a while. And then what to expect every month and how to prepare. It's emotionally draining and physically draining, not to mention trying to also, you know, put out the same amount of work in your real jobs or other jobs where people have not let up expectations. Thank you, everyone. I just wanted just to share that is, you know, but that sentiment. But
Thank you.
with that
There's
said,
one other thing I should mention that I forgot is that, you know, with Diane's departure and her retirement, there is now a new legislative council. Kara Jenkins was appointed by the legislature to be legislative counsel. Since she serves on the commission ex officio, she is now also a member of this commission. And I spoke with her and she was not able to make this meeting, which doesn't surprise me at all because it's like immediately after she assumes all of her new responsibilities. But I'm in communication with her and we'll be talking to her about attending the next one, which will probably be easier if it's February, frankly. So we hope to have a new face in a little box pretty soon. That's it.
Hollywood Squares box.
Yeah.
Any commissioner suggestions this
Did you
time?
say hospital squares?
It's just not a hospital. It feels like hospital.
The newest game show.
Hollywood Squares. But I like hospital squares. That's not funny though. Right. Commissioner suggestions? None. All right, then we'll go to the next topic, the annual report. Steve, I was going to tell you in your absence, I don't have any, I'm not going to make any changes. Aren't you surprised?
No, you're kidding. I was looking forward to that. I thought you were going to have.
Gift.
All right, so this is memorandum 2020-66, which presents a draft of the Commission's 2020-21 annual report, and also presents one of the appendices that goes with the report, which is the biographies of each of the commissioners. There are a few other recurring appendices which are not presented. The staff updates those. If you're interested, those are listed on the page 6 of the table of contents of the annual report. A fair amount of the report is pretty standard from year to year. A couple areas that I want to ask about. One, does anyone have any changes to their biographies in the appendix? That's appendix number 4, which was attached to the back of the annual report. Okay, I'm seeing none. That's great. The next part that I guess I want to bring your attention to is just to make sure here, the legislative program, which is indicated for 2021, is on page 11 of the report. This is mostly taken from the decisions that the commission made when they considered new topics and priorities at a previous meeting, but just to double check to make sure this is consistent with the commission's wishes for the coming year. There's also a little summary below that says commission activities plan for 2021. In years past, we have occasionally had some shaded area in here where there was some question. I don't know that exists now, but I just wanted to double check. I'm seeing nothing here. The next thing that I need to know about is on page 28. Oh, I'm sorry, Commissioner Carrillo.
Yeah, I had a question about, it's page 7 of memo 20-66.
Okay.
It's the, I guess the cover letter to the governor.
Right.
Can we take out the italics on Governor of California?
I'm seeing Brian mouth no, but I don't know. This is we've just
I
done
can't see
it that way.
why we wouldn't if you feel strongly about it and nobody else does.
Okay.
I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I can't see why we wouldn't if you feel strongly about it and nobody else does. I I mean, it's our traditional style, but if we were to change the style going forward and stick consistently to the new style so it doesn't look like inadvertence, I don't see
Yeah,
the reason.
same thing with Crystal's title. No disrespect, but I can't see a style reason why people's titles would be italicized.
I agree.
Oh, at the end,
Yeah, where's this
Right.
chairperson?
right.
And Crystal, that's not a demotion.
Well, so would that be going forward then? I assume that we would do.
I
it
would
this way?
like that to be the decision. If we're going to change it, that would
Yeah.
flip it, so it doesn't flip.
Are you guys
Okay,
all okay
so-
with it? So you got a full house assent. You're good.
Yeah,
Wow.
okay, that's fine.
So much winning.
I don't think there's any, I don't think there's any other similar italics anywhere else in the report. Do we have letters on recommendations too, though, right? Or do we not have the letters on recommendations?
We have letters on the recommendations.
Yeah, if we make this change, we'll make it globally for every document produced or approved from this date on.
And
Okay,
Steve, I guess on a related subject, do we need to note anywhere in this document that there's a pending issue about whether the commission is going to change its citation style going forward? Or is that an internal thing? I haven't forgotten about that, Brian.
That's an
I-
internal thing. I don't think we have to discuss it in the report.
Okay.
That's part of the reason why I want to cancel the January meeting, because I just can't bring myself to do it that soon. It's going to take me longer to get my head around it.
That's fine. That's all I have.
all right. So I have that decision. Now on page 28, we ask in the report for any commissioner activities over the past year, or actually since last November of last year, that would be appropriately included. This is a summary of activities that are specifically related to the commission in some way. There's one example of something that Brian had done that you can look at. We rarely have anything. Occasionally we do have something, but I need to ask.
It's more common for the staff to do it. Like when we were first doing the Public Records Act study, I made an appearance, I think, at a lunch of the municipal attorney section of the state bar or something like that, where I just talked to them about our project. So it really, if you have an event where you spoke about the commission's work, that's the kind of thing we would memorialize here.
Okay, I'm seeing nothing from anyone, no indication from anyone.
Yeah,
last
I am
question.
looking though at the style, because you have it throughout, the italics. I don't know what you're gonna do to distinguish how it's read or how you identify titles throughout. So I don't know if it's going to be that easy as just removing the italics. Because then are you gonna change the font size?
We would
Looking
just,
just at page 26 for the staff, for just everything. I mean, it's probably throughout. I don't think-
as I understood David's motion, it was just to remove italics as a way of designating titles.
Well, we have on, I mean, Commissioner Miller O'Brien is correct on page 26. They are listed as titles under the members and the staff have.
And it has always been that way.
But you know, we could limit it to letters. I mean, you know, as opposed to this, but so I guess everyone needs to look at page 26 of the draft.
Yeah, because I do know that when you're looking at the hard copy books, David, it is easier to identify who's what, why, you know, how the titles are there. So if you were just in a style, I too like styles. So, but it's like, you would have to, there's no direction given in terms of the font size. How are you going to distinguish it? And it's not so much as, you know, just personal interest. It is going to be an issue, and it has never been that changed. Not that I'm married to permanency, but go ahead.
I would construe the decision narrowly, not so narrowly as to limit it to the letter of transmittal, but that the decision was not to use italics to designate positions and not change anything else. And so looking at page 26, sorry, where it says chairperson, it would continue to say chairperson, except it wouldn't be in italics.
Okay, but then what about the staff? So when you go, all of your names, so how is that Barbara's name and then her title, it's just going to be in the same block print?
Well, actually, now that you mention it,
Yeah, that's what
the
I'm saying. Not so much as me.
the names are in up and down caps. The titles are not. The titles are regular case. So there is a differentiation. We just wouldn't use italics. But I don't think anyone, if we took those italics away, I don't think we'd lose anything. I think it would still be obvious that my name is not Brian Hebert, Executive Director. That the first part's my name, the second line is my position. So, like I said, I would construe it narrowly and just de-italicize position titles and make no other changes.
How about at the top of page 26, under the members appointed by governor?
Yeah, same deal. Chairperson, vice chairperson.
Right, because we're not using all caps for the names there.
Right. There's not as great a degree of differentiation, but it is a different line. I mean, I don't think it would generate confusion to lose the italics. I think it's just purely a sort of a style preference.
I'm sorry to have ruined everyone's Christmas with this.
Not yet. Check back in 10 minutes if we're still talking about it.
I know. All right. If
All
I'm
right,
the only
well-
one, then I'll leave it alone. But yeah, it is nice when you do see it in hard print, because if otherwise you would just go, I mean, I don't know. I've gotten used to looking at it, but that's fine.
At the risk of prolonging this too much, I could share, I mean, I just changed it on my copy. I could share my screen, but I don't know that it's that important.
Well, what does it look like? Do you think it's an issue? If it's not, then we'll just leave.
Yeah. We don't, style
Okay.
issues, sometimes staff doesn't always see eye to eye, so it's a little, and I tend to be more nitpicky, so I'm not a good person to ask about.
Styles are arbitrary.
Right.
They're just about appearance and taste, so long as you apply them uniformly. If you don't apply them uniformly, then it looks like sloppiness. If you
Yeah.
apply them uniformly, it looks like a taste choice.
Well, unfortunately, we have the other commission though, the committee. So are you going to run all that by the committee as well?
No, and I'll tell you, the committee cares even less about style. They're going to make their own style choices, and their documents aren't going to look like ours.
Okay. Yeah, because I'm with Victor. That could have been an issue if it then is completely different on the other side too.
Well,
Anyway,
and
it's
I'll
a
answer-
non-issue.
I'll answer a question I think Victor raised at the last meeting about whether or not the reports of the committee are going to be integrated into the bound volumes of the commission. I don't believe so. I think they want to blaze their own trail and create their own record. So uniformity across components of a document is not going to be an issue.
And can I clarify the decision? So the decision would be to take out any italicized titles, is that correct? And make them non-italicized?
The last part, de-italicize
Yes.
titles.
Right,
Full
and is it part of the decision that the font should otherwise stay the same, or
Right.
okay,
Just the italics.
Yep.
right. Okay,
I would have given you discretion to play with the fonts, but
yeah, that's what I was wondering,
yeah,
change
because I would play
size
with
or
the fonts. Yeah.
whatever.
No, let's leave it alone.
Okay. All right, so not letters, but just for titles. Okay. So second to last question I have, a little hesitant to ask, is does anyone have any other editorial suggestions about the content of the report that we can implement either now or for future years or whatever? Okay, seeing none, all we have left is to approve the report for publication and transmission to the governor and the legislature,
Move to approve.
including the appendices.
Move approval.
I'll second it. Oh, we've got
Somebody
multiple
somebody
seconds.
moved
So
that.
You've
Is
got,
there?
you've got full assent. Everyone's okay in agreement.
All right,
To
excellent.
approve as presented.
Okay, thank you very much. Sorry to take so long.
You didn't, it wasn't your fault. All right, number 3, we'll move to that item. Study G400.
So these are 2 memos about reintroducing the commission's proposed recodification of the California Public Records Act and the necessary conforming revisions. The first memo is about the recodification itself. As discussed in the memo, there are a few changes that are necessary to update the proposal to reflect developments in the past legislative session. Not very many. They're described in the memo. I'm hoping a consent item, and hoping that you'll approve the revisions that are described in the memo. Does anybody have any concerns about them?
I move to approve.
Second.
There you go, Barbara. No one else has any questions? They don't have any questions. No one has questions. We're okay.
Okay, so I take it it's unanimous. And the other memo is about the conforming revisions. There are over 400 of them. Steve and I have been working hard to get those updated properly for reintroduction, but we haven't quite finished the process yet. And so there's nothing at this point for the commission to decide about that memo. If anything substantial, any substantial issue rises, then we will bring it up with the chair and or the vice chair in between meetings, or hold it if possible for when the commission meets. So I assume that's okay, and that's really all there is to these 2 memos.
Thank you, Barbara. All right, then we'll go to the next item. Sorry. I just exited out, I'm sorry. Okay. Number 4, we're on to the Stock Cooperatives and Uniform Transfer on Death Security Registration Act, study L3032.5. Brian? You're on mute.
Okay, the memo is 2069.
Yes.
In this study, we have been incrementally developing a proposal for a statute that would allow people who own an interest in a stock cooperative to designate that interest to be transferred on their death outside of probate. And the question has been like, how should this be done? And we've been building the apparatus for that. In the study, we've been looking at a couple of different existing statutes as potential model for how we might structure this statute. One is the Uniform Transfer on Death Securities Act, which is a uniform act. It's in California law that allows you to register your ownership of securities like shares of stock in TOD form, where you name a beneficiary. And when it's proven that you've died, the registering entity will re-register the ownership in the name of the beneficiary. That was sort of the first place we looked to as a potential model for the statute we're developing here, because in a stock co-op, your ownership of an interest is evidenced by a share of stock rather than a deed. The other model we've been looking at is the Revocable Transfer on Death Deed statute. That is a good model because it's very well developed. The commission fleshed out all the details of how that would operate, and those details were either affirmed or modified by the legislature, and in either case, they're a pretty good reflection of where the legislature stands as a matter of policy with respect to non-probate transfers of real property by a very simple mechanism. So we've been looking at that as a model, except where the character of a stock co-op is so different from other kinds of real property that it would justify deviation from that. So we've been moving through the various subordinate issues. The one that's addressed here is authentication. When a person creates an instrument that registers their interest in a stock co-op in TOD form, what should they be required to do to affirm that they're the person who did it and that it's an expression of their will, etc. And this is an important question for a couple of reasons. One is that throughout the years of work that we did with the legislature on the revocable transfer on death deed, by far the most significant concern that they've had is that allowing lay people to use their own instruments to convey title to real property on death without the advice of counsel is just an invitation to fraud, undue influence, and mistake. You know, the alternative way, if you want to do non-probate transfer of real property, would be a trust. And people can draft their own trusts too, but in most cases, or in many cases, people will enact a trust with the assistance of an attorney who, you know, knows what they're doing, has malpractice insurance, etc. So there's a little bit more protection of the property holder. So authentication is a big deal. The legislature cares about it very much. And in the original revocable, well, let me say, in the Uniform Transfer on Death Securities Act, there's really nothing there about authentication. And that's in part because it's not a mandatory statute. It's a permissive enabling statute. It allows registering entities to offer TOD registration as a service. If they do, the statute says that the registering entity decides on the process and formalities. So they can make their own forms, make their own rules about, you know, what hoops you have to jump through to do it, etc. It's left up to them. The revocable transfer on death deed statute is not that way. It has a lot of very strict mandatory rules about how you go about making one. You have to use a statutory form, you have to sign it, you have to have your signature notarized, you have to record the document within 60 days of your death. And then when you die, the beneficiary has to bring proof of your death and record it in order to establish the rights of bona fide purchasers or encumbrances, which is necessary for the marketability of the title that they've received. So it's a fairly strict process that relies heavily on recordation and title insurance to perfect the transfer. The commission, in its follow-up study of that statute, recommended 2 additional formalities. Witnessing, which we modeled after the law of witnessing for wills, and notice post-transferor death, notice to the deceased transferor's heirs as a condition of perfecting your title as a beneficiary. You have to notify the heirs, the decedent died, they executed this RTOD deed that I've copied to you, I'm the beneficiary. If you want to sue to try and overturn this, the clock is running, right? So we recommended those additional steps. So the question before us now is if there is this mechanism for registration of your stock co-op interest in TOD form, what do we want to include as authentication requirements, drawing from the menu that's in the RTOD deed statute or otherwise. I point out in the menu that in the memo that there are 3 considerations that I think weigh pretty heavily on this decision. The first is, we don't know yet whether the legislature is going to agree with our recommendation to add witnessing and notice to heirs to the existing RTOD deed statute. That's our proposal. It was introduced last year, but that bill got pulled because of the pandemic. I'm expecting it to be reintroduced this year. But if it's reintroduced this year, we won't know until September, October, probably, whether or not the legislature says, yes, that's a good idea. And so it's a little bit dicey to model this new proposal on reforms that we don't know yet whether the legislature is going to like them and think they're appropriate. I mean, part of the value of borrowing elements from the RTOD deed statute is having uniformity across statutes that do similar things. And also making it easier for the legislature to accept the propriety of what we're doing in this study, because it's the same thing that they just blessed over in this other similar context. So that's one consideration, is we don't know yet whether witnessing and notice to heirs is going to be acceptable. So if the commission decides it wants to include those kinds of elements in this statute, I think it should have an asterisk on that decision, which is subject to revisiting the decision once the RTOD deed statute has passed muster in the legislature, so we can reevaluate in the context of what they've done. So that's point number one. Point number two, and this was something that I've been waiting for a few months to get information on, has to do with recording and title insurance. One of the reasons that we're expecting that this statute is going to be different than the RTOD deed statute. The reason this kind of property was carved out of the RTOD deed statute is because it doesn't involve a deed. It's still an interest in real property, but there's no deed. And so the formalities that we established around execution of a deed and recordation of that deed may not be apt for an interest in a stock co-op. And that's what I have confirmed. It's a little more complicated than that. The paperwork that you have as a member in a stock co-op can be a certificate of stock, but it can also be what people have called a membership agreement, a proprietary lease. There are various, an occupancy agreement is one I've seen. There are various documents that have been developed to not just evidence your ownership right, but also regulate it. So that's where a lot of the use restrictions live. That's a recordable document. It's a document that affects real property. It can lawfully be recorded. But what I've learned is that in many cases, it is not. From what I understand, and I've spoken with a gentleman who's the head of of a nonprofit that promotes stock cooperatives, and a realtor in Walnut Creek who does a lot of work with Rossmore, where they have hundreds of stock cooperative units, and folks from a title/escrow office in Walnut Creek that works with that attorney and with Rossmore. So these are people who are involved in the conveyancing of these stock cooperative interests. They tell me that recordation is not required or done in general if the transfer is either donative, like a transfer on death, or it's an all cash deal with no lender financing. Because the point of the title insurance is to insure the lender's interest. And so if there is no lender, then you, as the person who's acquiring the property, you don't need it. You either have good title or you don't. And what I'm told is that all cash purchase without financing is fairly common in one kind of stock cooperative, the low equity housing co-ops. These are they're a statutory thing in California. These are the co-ops where they fix the unit purchase price artificially low to make it affordable. And a person who buys that acquires the right to live in the unit, but they do not accrue any equity. When they leave, they sell it back to the co-op at the price that they paid for it. I think maybe you can adjust for interest over that time, but housing appreciation in the housing market, you don't get that. because the co-op is then going to turn around and resell it at this artificially low price. So the prices are subsidized. And low enough, I guess, in many cases that the person who's moving in can just pay the price. They don't need a bank loan. So what I understand is that in some
Those
co-op,
for like affordable housing?
Yeah.
Unit, okay.
So in some co-ops, I think recording is almost unheard of. And title insurance the same, almost unheard of. In other co-ops, it sounds like it's hit and miss. You know, if the conveyance is as a consequence of death and through their operation of their estate, no recordation. If they sell it with a bank loan, recordation. And Rossmore is mostly market rate. So that's why those folks have that experience with that process. And they don't record a deed. They don't record the stock certificate. They record the occupancy agreement. So this sort of confirmed our expectations going into this study that some of the mechanisms that are in the RTOD deed statute would be a really poor fit for this kind of property. They could be used, but they just wouldn't mesh very well with established practice. And it was critical with the RTOD deeds that they mesh, because we were relying on title insurance as the mechanism for validation outside of the judicial process. So that was critical here, and this is my third point, so final one. There's an alternative which comes from the fact that when you're dealing with a stock co-op, there's another actor involved. The stock co-op is involved. And as I explained, this allows the use of what I've called a registration model rather than relying on recordation and title insurance. And I pointed out in the memo other instances where there is registration as a model for the way in which you establish a transfer on death designation. And in general, the registration is possible when there's a third party involved in the transaction. And it's either, in the examples I've given, it's either a third party who holds the property for the benefit of the owner, or it's a third party who's charged with maintaining official records of ownership. So this includes like a pay on death bank account. If I go into the bank and I say I want to designate a TOD beneficiary on the contents of my bank account, they'll hand you a form and you execute it and you hand it back to them. And that's it, you're done. They're holding the property, they control its disbursement, and they also maintain the official records of who has what rights. So it's very simple, and it's sort of the validation, authentication and validation is done by the bank through their sort of bureaucratic processes. Another example of that is vehicle registration. When I register my car or my mobile home, which can be a pretty sizable chunk of money, with the DMV, I have the option of designating a TOD beneficiary. And on my death, on proof of my death, the vehicle or mobile home will be re-registered in that person's name. They will become the owners as a consequence of this action facilitated by the state, because the state is the official registrar of ownership. And so it's simple for them to maintain these records in a reliable way. And on, they're using their methods for authenticating that you are who you are and you're doing what you're doing, they'll do it and take care of it for you. And the same model, although, without implementing detail, is used in this Uniform Transfer on Death Securities Act. If there is a registering entity. So for example, let's say you buy stock directly from a company and these are registered shares. In that case, you don't obtain like a fungible instrument that you can just go and hand to somebody and now they're the owner. That is possible. That's, I guess, bearer instruments operate that way. Whoever bears the instrument is the owner, but these registered stocks, ownership is evidenced by the registration process. So I buy these shares directly from the company. They register it in my name, and I own it, as evidenced by their record of ownership through their process for handling that record keeping function. And if I register it in TOD form and my beneficiary submits proof of my death, the registering entity re-registers it in the beneficiary's name. And so that's what regulates and validates the transfer of ownership, is the action of the registering entity. Here, we're in the similar space. We could rely on a registration process because with the stock co-ops, they hold the property for the benefit of the interest owner, and they maintain records of who owns the interest. And they do a lot more than that. They also like closely regulate that ownership interest through their governing documents and their governing process. So because there is a third party who is in that relationship to this interest and the owner of the interest, it is possible that we could use a simple registration model for authentication. And I sketch out in the memo what I mean by that. We could have a form. We've already decided that there's going to be a statutory form. The owner of the interest could sign the form in the presence of an agent of the corporation, of the stock co-op. The agent of the stock co-op could countersign. And both of those signatures could be require notarization if we want to go that route. So we know that the person is the person and the agent is the agent. And then the agent gives a copy of this document to the owner and maintains a copy in their own records and has the statutory duty of maintaining official title records for their interests. That includes this TOD designation. And then on my death as an owner, my beneficiary comes to the stock co-op, presents proof of my death, and they re-register it in my name. That model exists through, like I said, through a large swath of these kinds of transfer on non-probate transfers on death in cases where it is possible to do it that way. And I think it's a pretty reliable and simple way to do it. And at least as a starting point, I would suggest that we follow that general model of registration, which I think is contemplated in the Uniform Act we've been looking at, but is different from the RTOD deed statute. And to build this element of our proposed law on that registration model. Now, the next question, if the commission agrees with that, is whether you want to layer on top of that some additional requirements. So we could have a registration process, but still require disinterested witnesses of the signature as another layer of certainty. We could require notice to heirs before the title is re-registered so that they have a meaningful opportunity to contest the transfer if they think there's a problem with it. Those could be done in conjunction with a registration model. I'm not sure it's as critical. I mean, the thing about the TOD is the RTOD deed is that it's a very private instrument. You know, I don't have to really tell anybody that I've done it. I have to record it, but who's going to find it there? So there's a lot that goes on the front end that's really unregulated. And nobody's going to think to contest it until I'm dead and no longer available as a witness to say, yes, I meant to do that. And so I think that justifies putting a little bit more of the controls front end and back end that we've done on our TOD deed. I'm not so sure that's as necessary when you've got a third party disinterested agent who's participate in the process, who can serve as sort of a de facto witness and testify if there are disputes about whether you executed, whether it was actually you, what condition you seem to be in, whether somebody was there with you pressuring you to do it, that kind of thing. You would have this disinterested agent of the corporation who observes that process. My initial sort of instinct is that I don't think there's as much of a need for the witnessing. I'm less sure about the pre-transfer notice to heirs. I'm not sure that the agent process necessarily removes the impetus for that, because that's less about authenticating your identity and intentions and more about giving external actors, interested persons, meaningful opportunity to contest if they've got a problem with it. So I'm not sure that the registration process obviates that as much as it obviates or attenuates the need for witnessing. So I've said enough. The basic question before you is, are you comfortable with relying on a registration model as I've described it here? And if so, do you want to layer on top of it witnessing and or notice to heirs before the re-registration happens?
I'm glad Jane's here because I do want to hear your thoughts on it. And I actually was spending some time thinking about this, Brian. I like it, but I like the registration process, but I do think that it should not be a requirement for all of the steps, so that it could be, if it had been witnessed by disinterested witnesses or others, if it had also been a transfer prior to, or with family members or whatever. I just think that these could be, we can indicate maybe in the statute itself that a transfer or the registration may be established through elements such as the following, so that it's a list. I know, but it's because I think also too, I mean, like you said, the stock cooperative should be required. That's, how do we impose that responsibility on all stock co-ops?
Well, you'll remember the statute's optional. So
yeah, that's what I'm thinking. All of these should be optional.
We've already decided that the statute would be optional. So no stock co-op would be required to provide TOD registration. So if they agreed to do it, then they could voluntarily accede to all of the statutory requirements. That's how it would work.
Yeah, and I'm just thinking that if that was one way they did it, because like you said, the whole point of the TOD is that it is private. It's something that in my mind happens we had a recent death in our family. These things sometimes go so quickly and people just move and they do the best that they can, and requiring all these steps, those types of people, they would just have wills. They wouldn't even rely on, options like this. So I'm just thinking, I don't know how you can say these are some of the ways as opposed to requiring all of those elements.
I have two thoughts about that, and then I'll let Jane take the microphone. One is that I don't think we can get around the involvement of the stock co-op as a participant in the process.
I like it. No, that I like. It's just that I don't want that as a required element.
Well, let me emphasize, I don't think we can get around it operationally, because they actually hold the title. They actually issue the memberships. There is no way to acquire a membership in a stock co-op without the participation of the board. They are the ones who issue you your membership. So private actions outside of that process are eventually going to have to go into that process anyway.
No, that's true.
And the other thing I was going to say is that, just to emphasize that this could be very simple for the property owner, the registration process, just as it's really simple to register your vehicle TOD. When you register it with the DMV, you check a box and you name the beneficiary. That's it. There's going to be a statutory form. if your co-op provides this option, you would walk into the board or the board's office, wherever the property manager resides, and you'd say, I want to register my interest in TOD form, and they'd say, here's the form. Well, you'd have to have a notary, but maybe they have a notary in the office. And you'd fill it out. I state your name, my unit, my beneficiary, signed and dated, notarized, you're done. You hand it over, they make a copy, they give it to you, you put it in your file, you're done. The thing is, this is easier than the RTOD deed because they don't have to then go the extra step of running down to the county recorder's office and recording it. So I don't think this is going to be burdensome. I think it would actually in some ways be easier.
It sounds good, but then how do we prescribe the form? Are we asking the judicial council to do it? Are we including in the statute that this is an example of what would be required? Yeah, okay.
Not an example, we would mandate it. That's the approach they took in the RTOD deed statute. And you guys at an earlier meeting decided to do the same. It would be a very simple form, you know, I mean, it's just the name of the person, the owner, a description of the interest, signature and date, a scribing witness, you know, who's countersigning for the board, signature and date.
I think that's good. And it also helps. It's lay people friendly. It's good.
Jane?
Okay, so I was thinking through this. I absolutely, I think prescribing the form is good. I think notice to heirs, I don't think we need to do it. And I'll tell you why I feel that way, because we don't give notice. You don't give a notice to your heirs when you execute a will. You don't give a notice to your heirs when you execute a trust. If there is a prescribed form, then I think that obviously someone's free to contest it if they're going to contest that transaction at any time. But if you front load it with a notice to heirs at the beginning, then you're giving this a different type of standing than a normal estate planning document. I also think that notarization is essential. I think we have to do it for a lot of reasons. I think it would satisfy, I'm sure most stock cooperatives would require it. I also think that it ensures that the process is being taken seriously and carefully. With that said, I don't think we need witnessing. If we have, other than the stock cooperative person witnessing, then you have a notarization. I think we need to treat it as that type of a transaction and not just imbue it with so many layers that it becomes, then it defeats the entire purpose of doing this whole thing. So that's how I would view it. The form, notarization, you know, contact with the stock cooperative people. And then I think it is an effective document. It's met the threshold for veracity, and you're having someone else who's independent, you know, ascertain the identity. Witnessing is always tricky, I think. I mean, you know, people drum up witnesses. I will tell you from experience.
No, I know they do. But you know what, though? I was thinking, what if you had done that and you hadn't taken the other steps? What if you hadn't gone through the actual registration process and you are on your deathbed and you say, everyone in the room, I want Jane to have, you know, this interest?
You couldn't do it except by
Well,
will.
see, that's what I'm saying. Maybe we require some of these to help, because California, in keeping with our policies, we're very liberal on how we, you know, manage, you know, these quick testament, you know, you can just scribble what you want and that's sufficient. So why would we require, I mean, for property, you're right, you run into issues, but I'm just saying that this is supposed to be an easier option to a will. So.
But I think if following Brian's logic and what he's laid out in the memo, if we are following the steps of having to go through with the registration with the entity on the top, you know, I feel like it's a good idea. I think it should be sufficient. If someone makes an oral testament on their deathbed, then it's a whole nother, you know, that's a whole nother separate deal. That doesn't even factor in, frankly. Yeah.
Yeah.
Right. I mean, that anyway.
Well, see, Nat, I was thinking that maybe we make it clear that these aren't the only ways, but anyway.
But there is a
I mean, I do like the registration approach.
I think it's good, and I think an estate planning attorney would certainly look at that and see that, obviously you could leave that property to somebody without registering. I mean, whether you have to then navigate the hoops with the stock, whatever, that's fine. You know, it doesn't negate it, but.
But again, I'm still just thinking in terms of lay people. Someone gets COVID, they didn't realize it was that serious, they die. They don't have time to go to an estate planning attorney. So so I just want an option where you could maybe accomplish some things while you're in bed with a notary that travels, with a form that you could, have or execute. So, and then I was just, so I'm just wanted to be read, not requiring all of these steps. Anyway.
Well, that's the question. And I'll say one thing, Jane, and I'm not at all arguing for any particular outcome, but I think I was unclear in talking about the witnessing, or excuse me, the notice to heirs requirement. The intention was that what we did in the RTO deed statute was notice to heirs after the transferor's death as a way of giving a heads up that the instrument's about to operate. And we did draw that from the trust law. When a trust vests on the death of the settlor, becomes irrevocable, you have to give notice to heirs. And so we were looking at that as a back end, not complicating the front end of the notice or of the instrument.
Then that would be appropriate.
When I mentioned it, I was just thinking that it could serve as a way to establish what the testator's interests were.
Yeah.
So not so much as a requirement up front.
I don't think it's a complete answer to your issue, Crystal, but I would say that at the last meeting, we moved through a bunch of sort of nuts and bolts provisions fairly quickly, but one of those, I believe, was a section in the RTO deed statute that you decided to mirror in this proposed law that expressly says, this is not the only way you can do this. Well, I should say, this is not the only way you can transfer your property on death. It does not preclude other mechanisms.
There you go.
But if you want to do this, this is how you do it.
No, I like that. I think it's important to highlight that. Good.
Because if you die intestate, that property's still going to pass to your heirs by virtue of intestacy law, whether you execute this affidavit or not. So, but I agree, Crystal. I think it's good that you brought up that issue and that we've talked it through. And I'm sorry if I misconstrued what you meant, Brian, about that. So that makes sense to me. That's fine.
So I don't know. We need a decision, and if other people have questions or comments, we could have more discussion. But other than that, I think you need to decide first whether to rely on registration rather than a recordation title insurance type approach. And then, well, why don't we just start there?
Yeah, let's do that.
Formalities aside, registration as the underlying model for evidencing your TOD designation?
We're all nodding our heads.
Okay.
David, you're good too? Okay, yeah. So that's the plan for that. Definitely.
And then do you want to add a witnessing requirement at the time of signature? To heads down, not seeing any support for that. Third,
Just when you say witnessing, that's somebody other than the staff of the stock co-op. Okay.
right. That person's, I think, a de facto witness, but I'm talking about adding an additional separate requirement. Okay. And finally, do you want to include something similar to the RTO deed statute that requires the beneficiary to give notice to heirs after the death of the transferor, before the re-registration can occur? So in terms of the practicalities, in the RTO deed statute, we first established the duty. You must give notice to heirs. And we elaborated a lot about like what's sufficient to meet that duty and what are your standards and what's your liability. But first you have the duty. And then we said, once you've done that, you have to execute an affidavit affirming that you've done it and record that. because that creates the trigger in the title records for title insurers to rely on that, like, the process is good. We can proceed, you know, with insuring this title. They've done what they're legally required to do. And importantly, we didn't require title insurers to look beyond the existence of that document. They didn't have to evaluate whether in fact the person did what they were required to do. It was sufficient for the purposes of bona fide purchaser protection and title insurance that the person affirms that they did it. So we could do the same thing here. We could say before a stock co-op re-registers title in the name of the beneficiary, they have to receive proof of the transferor's death and an affidavit from the beneficiary that they gave notice to heirs of the specific type that we require. So that's a long way of saying, do you want to add a notice to heirs requirement at the back end before title is re-registered?
I don't want it. What do you guys think? I know,
It's just a question. Is this something that any of our audience wants to weigh in on?
don't have anyone.
We have 3 people. We have a phone number and 2 people who I won't name since they don't have to identify themselves. No, I'm not seeing any hands up.
Oh, I see the attendees. Okay.
I don't recognize the names as being people associated with Texcom.
Okay.
Oh, and just for the attendees, we had people last time that said they weren't clear on the process. If you want to talk or if you wanted to weigh in on an opinion, now's the time. And we're not so formal as to exclude you from that.
Okay.
Okay.
So Commissioner Kubas? She's gone. Okay. Trying to get a sense of where she was on the prior decisions, but we can circle back. So the third question is add notice to heirs, and I've seen some ambivalence, wishy-washy hand movements like this. So I'm not seeing anybody moving that. Is that correct? So in the absence of a move and a second, we just won't do it. It won't be a part of your decision.
I mean, if we did it on the RTO, I mean, we could be consistent. But honestly, it is messy. I'm with Jane. It gets messy once you start doing all of that. And you may need to re-register quickly to manage something.
Well, you only have to give this notice once, and that's if you're the beneficiary and you're about to take title. So it doesn't matter how many times the decedent like changed their mind. There's only going to be one beneficiary at the end of the race. And that's the person who gives the notice. But I don't see any support for it. And like I said in the memo, I think that there are material differences between stock co-ops and other kinds of real property that justify deviation from the RTOD deed statute. And the availability of this registration option, I think, is a big deal. It really does put it in a different posture. And it maybe makes sense to be more relaxed and reliant on the entity.
I think we're good. So,
so the decision I hear is no notice on the back end.
Jane has, Jane, go ahead. Do you want to?
No, I was thinking about it and I was trying to think of an analogy about why we wouldn't do it. So let's say you bought a life insurance policy, right? Or something like that. You don't notify people about that. I mean, normally I agree with how we structured it for the previous, but I just don't know that it's that imperative here. I mean, maybe that's just me. So sorry, didn't mean to cut you off, Brian.
No, that's all right. I can't think of an example of this in any registration context, but I'm not certain. Is Kristen, are you there? Kristen knows more about the vehicle registration law than I do. I haven't looked at it as closely as she has. Is there any kind of process before they will re-register title that requires the named beneficiary to notify other heirs?
Brian, I don't know. Can you
Okay.
hear me?
Yeah.
I don't know offhand, unfortunately.
I can just tell, I mean, my son inherited a car. We didn't notice anybody. That's just silly. I don't think you have to do that.
You just walk into DMV with a death certificate.
We went to AAA. It
Yeah.
was simple.
Okay, I don't see any contrary views on that, and that's all I have. I'm done.
Okay.
Thank you.
Oh, but you are going to use, you are going to borrow from the RTO TV where we say, this is not the only, okay, so good. Yeah, so I wanted you to add that. And then
Yep.
I feel good about what you've done. Yeah.
Commissioner Kubas, your video flickered on and off at various points in that discussion. Can I list you as having assented to the decisions?
Yeah, whatever the majority said. I'm sorry, I had the electrician over at my house. This is the only time I could get someone to come. My apologies for that.
No, we just wanted to make sure you weren't freezing and going.
Yeah, thank you.
All right, so with that, then we're on to agenda item number 5. We're almost done, you guys. Recodification of toxic substances statutes. And
Yep. And so that's mine. Can everybody hear me? This is my first time using this headset, so okay, great. So this is memo 2020-70. This continues the discussion that was presented at the last meeting. So at that meeting, the commission started walking through the different issues that we needed to resolve in order to finalize.
Get Brian's attention. Brian, can you mute your screen? Oh, there. Okay, go ahead, Kirsten.
No problem.
I don't think I'm the source of background noise. I think it's somebody else.
Okay.
I don't know. There might be some background noise coming in here too. So for this, we were working on trying to finalize our recommendation for the recodification of Chapter 6.8, and this memo continues that discussion. We use the same procedures in this memo for proposed consent, and actually nearly everything in this memo is a proposed consent item. So there's very little that we'll need to discuss unless the commissioners have any concerns or want to change, want more information. The only decision point for the commission is one issue that came up at the last meeting, and it's the first item discussed in the memo. It's proposed section 68200. And in this section, the existing law obligated the director of finance to schedule certain projects specifically in the Budget Act. And it was that language that was problematic. And we've proposed a change to refer instead to the proposed budget. We found there's a footnote to another section that uses that language. And I just wanted to get the commission's decision on whether or not that was an acceptable resolution.
That's fine.
Anyone in opposition? No? Okay, you have full
Looks
assent.
good. Okay, we've got full assent on that. So aside from 2 issues, which I'll just flag briefly for the commission, everything else is proposed consent, so we'll just take a consent vote at the end. There are 2 matters that are discussed briefly in this memo where we were seeking comment. DTSC commented, and there's still some outstanding issue about how we're going to resolve those matters. And in those cases, we'll just be bringing them back in a future memo. I don't expect that those will prevent us from preparing a draft final recommendation. That's going to be the next step in this process. So we're working with DTSC, and hopefully we'll get some more feedback so that we can resolve those issues and get a draft final recommendation before the commission, both on this issue, the recodification, and the conforming revisions. As Barbara mentioned, one of the things that we're also going to do to prepare that draft final recommendation is update any of the legislative changes. In this case, Chapter 6.8, there were no changes in the legislature this year, but our conforming revisions document, there were several provisions that we've updated. So aside from that, I just need a commission decision on whether or not to approve the proposed consent matters. If there's anything the commission wants to discuss on that, I'm happy to talk about any of those items. But I'm seeing no issues to discuss. I'm seeing a lot of thumbs up. So it looks like those proposed consent matters are approved. So we're well on our way. Next steps, like I said, we'll just be preparing draft final recommendations for the commission to review and approve. And we'll address the final outstanding issue we've highlighted in this memo when we do that. And that's it. Thank you, commissioners.
Thank you. You moved through that like a smooth pilot. That's what you got your head set together. All right, with that, then there are no other items. Did you guys, well, just say something that I guess we're almost done, but if you guys just want to just share really quickly, just something that you want to go into 2021 with, being either hopeful for or thankful for, saying goodbye. We'll just go through the room really quickly, just a way to say goodbye. Rick, do you want to start? You good?
Yeah, I'm good. Hope all of you guys have a wonderful holiday. I'm going to be seeing my grandkids via Zoom, so have a wonderful holiday season.
Jane?
He had to put me on spot. You know, it sounds really crazy. And we've talked a lot before the meeting started about what were the logistics we're going through this. I'm just telling y'all, I just want to hug my friends, my family. That's me. 2021, man, I just want to grab somebody super tight. And I'm probably going to be a total limpet on everyone I know. So that's what I want to think moving forward. And I'm thankful for all of you, for all your insights and the work we've done together this year.
It's nice. David?
I've never been so grateful for government service as I have been this year. Getting to spend time with you folks every month has just been absolutely fantastic, and it's really helped me get through this. So I'm very grateful for all of you.
Very nice. Victor?
I wish for a successful implementation of the California Public Records Act revisions. But happy holidays, everyone.
Richard?
Hi, I'm hoping that we have a better year next year, and I can't see how it can't be given this year. And I don't know how many of you are at a point in your lives when you have grandchildren, but I have 5 of them. They're all succeeding, doing well, and hopeful of leaving isolation. And they're going through all this restructuring process that some of you talked about earlier, where the schools are trying to find out how to give people an education without interrupting it the way it has been. And I'm hoping that we'll find a way to resolve that, because it's important that they don't be left behind. So with that said, I also would add that I am very, very, very impressed with the scholarship of this commission. It's an extraordinary group of people that you are, staff included in that comment, who are doing incredibly great work, obscure in many times. Many of us out here didn't know what you were doing. I, for one, was one of them. And I am very appreciative of the fact that you spend so much time putting these efforts into place. And I hope it's good for the benefit of California and for the nation itself. So happy Hanukkah, happy Christmas, happy whatever you're celebrating. And thanks for letting me be part of this exercise.
These are nice, you guys. Very good. Anna?
Hi, well, I'm grateful to Brian and the team for keeping us going. You are one of my Zoom families now. As a new commissioner, of course, I actually enjoyed going to Sacramento and seeing you all and having lunch with you all. So I really miss that. So my wish for next year is that soon we can resume that and be safe and happy together.
Kristen? Very nice.
So I appreciate everybody being so adaptable and understanding through this challenging time. This has been a real amazing process to see how quickly the commission was able to sort of respond to this and, you know, stay on business and keep working through the things we need to work on, even through all of these challenges. I wish everyone good health and good cheer through the holiday season, and I look forward to seeing you all in 2021.
Brian?
Sure. Well, one thing I would be nice. I'm grateful that for the new commissioners that our January meeting was in person, so that we got a chance to meet and like have lunch together and be a little social. I share David's appreciation for government. I think that this is the kind of time when the role of government is really clear. And, you know, I've had the opportunity as the head of an agency, as tiny as we are, I'm nominally, you know, the same status as agency secretaries and directors all through government. And so I've been sitting as a fly on the wall in the Zoom meetings, the all agency director Zoom meetings, and listening to everything that's been going on to steer California through this crisis. It's gratifying and impressive, that kind of public service. And then I'll finish with a selfish one, which is my first grandchild, my daughter Logan, is now I think 14 months old.
Oh, fun. I didn't know you had a new grandchild. That's cool.
And I've probably been physically with her 4 or 5 times now, or less than a day. And so I'm really looking forward to having a chance to be more physically present with her. I'm missing it.
Of course.
Yeah.
Nice. Well, congratulations too on the new grandbaby. Barbara?
Well, I want to say I am very thankful that the commission, the current commission, that all of you are coming to the meetings and always well prepared, consistent participation. That makes a huge difference. And I really appreciate it. And I also really appreciate the way that Brian and Victor together were able to steer the transition from meeting in person to meeting by Zoom, because I think it has been successful, and that was not something that any of us foresaw and had any time to plan for, and it really seems to have worked out pretty well. And I guess the last thing I just want to say is that I really miss the part of being able to interact with the members of the commission and the staff in person, and I look forward to when we can do that again.
Very nice. And really good point. And they created, Brian and Victor, you guys created a blueprint for what we can expect from these meetings. And I do think that does contribute to all of us, figuring out how to get locked in when, we have the meeting scheduled. Thank you.
We've never been Zoom bombed.
Steve?
Thanks. I wish everyone and their families absolutely the best until we're out of this. And I guess my other wish is that everyone can try to find something positive. This is terrible, but it is a rare opportunity and circumstance. And there may be something in here somewhere that we can all look at as something that we never would have been able to develop or take advantage of in the past. So there might be some positive that comes out of it with all the negative. And I
My
wish
dog is
everyone...
really happy.
No, I think it's, there's always, you hope that there's always something that can be positive from bad or from tragedy. Basically, this is a crisis, and it really is one, and we sometimes forget, I think. Deborah, can you get good?
Oh, hi. I just am thankful that we have jobs, a lot of the people around us right now I'm seeing are really struggling, and you can be appreciative for just having work and a stable living. A lot of small business is really suffering right now. So,
really good point. You guys, I'm sending you a virtual hug. Thank you, everyone. I'm sorry to keep you, but this I think was good. We can't connect. So this is, normally the new commissioners, you don't know, but usually Brian books us into some nice hotel and we have a good lunch, and we can't celebrate really. But this was a little bit of a celebration. I think we all have to be creative right now. Anyway, thank you, everyone. And I'll go ahead, we'll convene right now. We're done.
All right.
Nico and Sarah, I hope this was helpful for you to participate. We didn't hear from you, but you're welcome to come back and join us in February.
See you in
Bye,
February.
everyone. Happy holidays.
Bye. Happy holidays. Best to everyone.
Yep.
Bye.